Hello, everyone. Welcome. Thank you for attending the second in Venable's Deregulation Nation session. We're going to be talking today about the Federal Trade Commission. I'm Len Gordon. I lead the advertising and marketing practice here at Venable. I'm joined by my friend and colleague and partner, Shahin Rothermel, and we look forward to talking to you today. Very interesting topic as to how the deregulatory efforts of the Trump administration impact the Federal Trade Commission. We'll cover today where things stand now at the FTC, the FTC's deregulatory efforts, the Congressional Review Act, and how the states and the plaintiffs' bar have reacted and perhaps affirmatively acted in response to what's going on at the FTC. So, as most of you probably know, the FTC is an independent agency. It is supposed to consist of 5 commissioners, no more than 3 being of the same political party. The president gets to pick the chairman, usually of his or her political party. The Trump administration has declared war on the administrative state and seeks to fundamentally change the way the FTC and other independent agencies work. There is a theory in constitutional law called the unitary executive, and that is that all executive power resides in Article 1, the executive, and that administrative agencies such as the FTC have to be under the full control of the White House. And that is happening at the FTC. The president has fired both Democratic commissioners and indicated that he has no intention to replace them with other Democratic commissioners. We now have a full slate of Republican commissioners. We've got 3 Republican commissioners. Andrew Ferguson is the chairman. He's a former Solicitor General from Virginia. He's done a lot of litigation. Melissa Holyoke, another former Solicitor General, this time from Utah, also with a litigation background. And Mark Nader, former Deputy Chief Counsel for Antitrust and Competition Policy for Senator Lee. He has actually worked at the FTC. The other 2 commissioners had not worked at the FTC previously. And so, sometimes you get commissioners who have a lot of experience there or appearing before there. Other times you don't. Here you've got 2 commissioners who really have very limited experience with the agency. All right, let's go to the next slide. Thanks, Shahin. So, as I mentioned, it's not just the FTC. The NLRB and other agencies have been in the crosshairs here. Earlier this year, the Supreme Court ruled that the president's firing of NLRB members without cause can remain. The issue here is, do members of these commissions serve at the pleasure of the president, or can they only be terminated for cause, which is how the statute reads? The Supreme Court decided not to disturb, on a preliminary injunction, the firing and wait for a trial on the merits. Not surprisingly, Justice Kagan dissented, talking about the president overruling Humphreys. And the Justice Department has made clear in letters to courts and public pronouncements that it does intend to overturn Humphreys. And I'll tell you in a second what Humphreys is. But the president essentially is, acting on a course that sort of says this case was decided wrongly, and I'm going to ignore it. So what does Humphreys say? Humphreys is a case from the 30s involving the FTC. It was decided when a commissioner was fired and ruled that the president could not fire a commissioner without cause, and that was not within the Article 1 powers of the president. What the court held is that the FTC has this sort of unique status. It promulgates rules, it adjudicates cases, so that it's got a little bit of the executive because it prosecutes cases. It's got a little bit of Article 3, the judiciary, because it hears and decides cases. It's got a little bit of the Article 2, the Congress, because it makes rules and regulations. And at least in 1935, I think when the case was decided, the court ruled that the FTC was predominantly a rulemaker and an adjudicator, and because those functions were not sort of unique to the executive, the FTC was not fully within the executive's power to terminate without any need to show cause, and therefore the FTC was constitutional because the way it protected its commissioners from termination without cause. There are several people in the Supreme Court who think that case is wrongly decided. They've hinted that repeatedly. The Justice Department, as I mentioned, has sent letters in these NLRB cases before the FTC firings, indicating that they were not going to, that they thought Humphrey's executor should be overturned. So we'll see. I mean, the FTC case is moving quickly. There's no facts to be discovered. There's no discovery. You're going to have cross motions for summary judgment. I think the briefing is complete. It will go, maybe all these cases will end up getting consolidated and go to the Supreme Court at one time. Go to the DC Circuit first. It'll be interesting to see if the administration tries to fast track it to the Supreme Court. But they're firing people, so that they don't see the need to hurry. We'll see. But that leaves the FTC and completely controlled by the Republican Party. And we'll talk a little bit about what that means as things start going forward. But I'm going to turn it over to Shahin now to talk about the deregulatory efforts at the FTC and also talking about what happened in the prior administration, because like most things in Washington, the pendulum swings back and forth, and that's certainly true right now.
Thanks, Len. Absolutely. When we saw the previous administration and the prior FTC, it was a very different place than what we are seeing now and what we anticipate to see over the next few months and years. Under Commissioner Khan, Chairwoman Khan, they were on a rulemaking blitz. I remember, Len, you and I a few years ago, or maybe it was even just last year, we did the Rule-a-Palooza.
Rule-a-Palooza, exactly.
The Rule-a-Palooza webinar. And we went very deep into a lot of different rules that had been proposed and were being amended and were undergoing the rulemaking process, where we saw workshops and input from relevant stakeholders being requested by the FTC. The FTC had done that primarily because the AMG Supreme Court case finding that they could not obtain monetary penalties under the general Section 53 provision. In other words, the court said, you FTC are going to have to find another way to get money. And what the FTC said was, okay, we'll pass a bunch of rules. We'll say there'll be trade regulation rules, which carry their own civil penalties, or rules that will essentially put the industry on notice of certain types of acts, and then we'll use that as a way to get monetary penalties. What was interesting was we did see a lot of rulemaking, but not necessarily a lot of them passed. For example, we did see the negative option rule. You can see here that that's the first one. That did become final. That was finalized. It was challenged in court. And a lot of people thought, okay, well, the new administration, the new FTC is not going to defend that. It's completely deregulated. And the theme, if you have one takeaway from this webinar, is that, yes, we are seeing deregulation from a lot of the agencies by the new administration. The Federal Trade Commission isn't necessarily one that I would say the wicked witch is dead. They're not going to do anything. They're completely deregulated, because the FTC is continuing to defend the negative option rule. It has delayed the implementation, which we'll talk about, but it's also brought a number of cases and settled cases under rules related to negative option. And by that, we mean subscription marketing, auto renewal continuity, that type of thing. The non-compete rule, which would have banned non-competes in certain contracts, was finalized, but it was set aside by the court after that challenge. The combating auto retail scams, or CARS rule, was also finalized, but the FTC stayed enforcement of it after a court challenge. There was also the junk fees rule, the rule prohibiting unfair deceptive fees. that would have previously applied to all industries, saying you can't have any drip pricing. You have to essentially disclose all-in pricing at the time you're making any type of pricing representation. You can't just put it on the checkout page. That was, and when we saw the final rule, it was actually scaled back immensely so that it did not apply to all industries, but rather really to what I'll call the hospitality industry and those types of industries. A couple of other rules you can see here were finalized, but some of them were only proposed, and the FTC isn't really doing anything with those rules right now for the most part. And we provided here the status of each and where they are. Len, do you want to talk about the public inquiry into anti-competitive regulations?
Sure. So it's interesting, the FTC with its competition hat on is been tasked by the president, working with the Justice Department, to look at other administrative agencies and cabinet departments who have promulgated regulations to determine whether those agencies have unnecessary regulations that burden the economy, increase the cost of doing business. I suspect that certain DEI regulations are in the crosshairs. I would suspect that certain environmental regulations would be in the crosshairs. But the FTC has started this process by opening things up to public comment, looking for regulations that create unnecessary barriers to new market participants, barriers to entry, contain or create licensure or accreditation requirements that unduly limit competition. Do you really need to have a license to perform as a beautician? Do you really need to have a license? There's been a lot of scrutiny about whether hospital certificate of need laws at the state level unduly thwart competition. Are there regulations that thwart agencies' procurement process, making it more expensive for the government to operate as it goes to buy things? Or in any other way imposes anti-competitive restraints or distorts the operation of the market in a way that ought to be stopped. We'll see how much actually gets done here, but it's certainly part of the anti-regulation mantra that parts of the Trump administration have been touting. So the chairman went down to the Hill a few weeks ago to talk about the FTC's budget, and what he had to say was really interesting. His remarks are typed up if you're really bored and want to read them on the FTC website. He was quite clear that he is shrinking the agency. He thinks it's got too big. Had kind of come down to about 1,100 employees. That'll be done through, there's already been some rifts of probationary employees. People are being offered sort of fork in the road offers. You can retire with a package, or we'll probably push you out. And attrition. There are rumors that a lot of the sort of senior bureau heads that are going to be pushed out, which will leave something of a brain drain, I think, at the agency. I'd be curious to see what happens in that regard. He talked about the agency's priorities, and one of the things that he said that is directly relevant to what we're talking about today is, and it reflects his background. He comes at this as a litigator. He said, we're a law enforcement agency. Our job is to enforce the laws that Congress has passed, not to write regulations that Congress may or may not have authorized. So I don't think you're going to see much more regulations getting promulgated under Chair Ferguson. I was one of the people, like as Shahin mentioned, who was kind of shocked when they defended the negative option click to cancel rule. But we'll see. But so far that's on the books, and they're using it. He didn't mention though the click to cancel rule when he talked about item 1 on his agenda there. Deceptive fees billing, and that's noteworthy. The other thing that was noteworthy by omission is he didn't mention in his testimony the need to restore the agency's ability to obtain equitable monetary relief under Section 13B of the FTC Act, which, as he mentioned, they lost that ability in the AMG case. That's odd. In prior Republicans and Democrats alike, when they went to the Hill, always made that plea. So we'll see what happens. But, while there's a lot that would indicate, this is a much different administration than Lena Khan's, there are some striking similarities. Both are very focused on worker rights, both from the competition point of view. What would a merger mean to employees? That's relatively a new focus and was a very clear focus of the Khan-Biden administration. And the chair here has issued a memo creating a task force to work on this issue. It also translates to consumer protection issues such as training scams. I'm going to use this word scams broadly here. Money-making scams, work-at-home scams, veterans scams, all things that would sort of impact employees. And all of those were traditionally, priorities under Chair Khan. And frankly, it shows that in many ways, the FTC historically, the Consumer Protection Mission has been fairly bipartisan. No one's a huge fan of fraud. I think there are differences with Chair Khan wishing to regulate conduct and Chairman Ferguson saying he just wants to sue people. So we'll see what happens next. But they're also, with the shrunken workforce, they're going to have to probably do a little bit more triage on what cases they bring.
Absolutely. And I think we put a couple of these of what he talked about, but it bears repeating that we are seeing investigations, we're seeing civil investigative demands, we are seeing publicly filed lawsuits and settlements. And if this is not something, the enforcement is not something that we're expecting to see. It might be different, but it's certainly not going to go away. And one thing that we saw under the Trump administration, the first one, was that there were actually, I believe, more there were more enforcement actions than there were under the new administration under Biden, which was really interesting. So we do see, as Len, you said, different that tension. But I would almost say, if you're looking at it, a lot of companies and a lot of our clients are in maybe a riskier position than they might have been under the previous administration.
Under Chair Khan, tremendous resources were devoted to rulemaking. Those resources arguably will now be freed up to do enforcement. And your point about Trump 1 is absolutely right. I was sitting with former FTC colleagues and we were lamenting the position the agency was taking in a case we're all working on. And one of them said, well, this would never happen if there was a Republican in the White House. And that was a joke. But it shows that, there was consumer protection was pretty active during Trump 1. And I think as this administration, they find their footing, the people learn how to do what they need to do. A lot of these people are new to these jobs and these agencies. You'll see more enforcement.
Absolutely. Although this one might be,
so
the rule.
You do have this sort of schizophrenia where you've got this Chair Ferguson's going, we're going to vigorously enforce the laws, and at the same time we're also saying we're going to get rid of regulation. And I think one of the areas where you see that tension is in regards to the Robinson-Patman Act. It's a antitrust statute from the Great Depression that deals with price discrimination, and the FTC dismissed the lawsuit against PepsiCo that the Khan administration had brought, finding it was just, the facts just didn't support it. But there is a Robinson-Patman Act case in the spirits industry that the agency is going great guns on and, devoting resources to. So that Robinson-Patman Act enforcement would not typically be something you would see in a Republican administration, but I think, we're in a new world as far as, what Republican priorities are at many agencies.
Absolutely. And we're still seeing the FTC enforce a number of other types of cases, including ones that related to the 6 points that we talked about that were priorities. There have been delays for some compliance states that would apply to advertisers and marketers. The biggest one was the negative option rule. When the negative option rule was initially proposed, we were all ready for it to go into effect primarily on May 14th of this year. Some of the prohibitions on misrepresentations did go into effect in January. We also didn't know if the FTC was going to revoke the rule. We didn't know if the FTC was going to defend the challenge to the rule. And so far, it has moved forward, except in this regard. It has moved the compliance deadline to the primary aspects of the rule regarding what do you have to disclose about the auto renewal terms? How do you get consent to the auto renewal terms? What types of cancellation mechanisms do you have to provide for somebody who's in a subscription program? Those were supposed to take effect in May 14th. A lot of companies were preparing for that deadline. And then they announced that they're going to delay the compliance deadline to July 14th. So they're giving people a little bit more time to get their ducks in a row on that. We don't have any reason to believe that they're going to do more in terms of delaying that compliance deadline. So in other words, if you would be otherwise subject to the negative option rule, don't assume that it's going to go away. A lot of people assumed it was going to go away in its entirety, and it didn't.
Yeah, one interesting thing about the negative option rule, and it's the second bullet here, is the broad prohibition on misrepresenting material facts and selling any good or service with a negative option feature. I mean, in some ways, this rule is a bit of a Trojan horse, because what this provision of the rule does is for any product that is sold on a continuity basis, has any kind of negative option feature, it allows the FTC a mechanism, because it's a rule, for a rule violation to obtain either redress under Section 19 of the FTC Act and or civil penalties, which are like $58,000 per violation. It'll be very curious to see, as they move forward, if they start bringing cases under the rule, whether they use this provision of the rule. When the rule was being considered and promulgated, the Republican commissioners criticized lots of aspects of the rule as being overbroad, sort of beyond what the FTC had the authority to do, overly onerous, confusing in certain ways. But this provision in particular was attacked by the Republicans. Neither of them are now on the commission, but so it's going to be really curious to see if this provision is enforced and if the agency continues to defend it, because it dramatically increases the FTC's leverage in settlement negotiations with any company that they're investigating on negative option issues, because they can use misrepresenting material fact. That's a pretty factual inquiry that's not going to be right for getting rid of things on motions for summary judgment. I mean, at least motions to dismiss, probably. I mean, we'll have to see what the cases show, but that's a very fact-intensive standard, which might require summary judgment or even trial. So that I think how the agency enforces that provision may be a real window into what we can foresee for the rest of the administration.
Absolutely, because it gives them carte blanche. If you're selling on a subscription or a negative option program, this lets them in, as you said, a Trojan horse to go after whatever they want, including the technical violations, or what we would consider technical violations of the subscription, things like disclosures of the amount and on the monthly basis versus on a weekly basis, this type of thing. One of the things that the agency said when they delayed the compliance deadline was they made the point that if their enforcement experience exposed problems with the rule, they would be open to amending the rule to address any such problems. And that I found really interesting, because what they were saying, I thought, was, hey, we might roll back some of these provisions in the rule, particularly some of the more onerous ones, such as what a lot of people are interpreting as requiring a separate checkbox to the auto renewal terms, providing all the disclosures before you even input your payment information, as opposed to providing the disclosures before somebody clicks pay now. Those types of things. I suspect the FTC might look more closely at those, but I also think, Glenn, I think with everything here, this FTC, instead of amending the rule, could simply decide to not enforce certain provisions of the rule. And that's exactly what you're saying, is that we don't necessarily know what they're going to do, but given the way these rules are written, what they do is going to give us insight into what they're also going to do.
That's consistent with Chairman Ferguson's language when he was on the Hill, and he's made this speech elsewhere. Then his job is to enforce the laws, not to write the laws. Well, every prosecutor has enormous discretion into what cases they bring, and I think we may be able to start figuring out some trends as to where the rubber's really meeting the road in the cases that the FTC is bringing.
Absolutely. And although we're not talking about the Federal Communications Commission today, one thing that the FCC regulates is telemarketing. That's where we see overlap between the Federal Trade Commission and the Federal Communications Commission, are regulations and laws surrounding telemarketing. And the FTC had, or FCC had two rules that it had promulgated, one of which it's essentially revoked, which was the one that would have eliminated the lead generator loophole and require one-to-one consent when you're getting consent to make certain types of marketing calls. The other really big one that would apply to anybody who's doing any type of outbound telephone calling, including informational calls, informational text reminders about a pickup or shipping reminder, as well as marketing texts. That was the revocation rule. And the FCC granted a waiver, allowing people an extra year to come into effect for certain parts of the rule, specifically whether or not if somebody says stop or revokes their consent to one type of call, whether or not that revokes the consent to all calls on unrelated matters, and particularly other lines of businesses that you're looking at there. Before we go further, we are going to talk about the Congressional Review Act. I want to give everybody the CLE code. That is FTC 2025. FTC, like the agency we're talking about right now, 2025.
So the Congressional Review Act is a powerful tool for Congress, working with the president, to undo things to undo regulation. There's concerns about the administrative state, and the statute was enacted as a way for Congress to check the power of administrative agencies by repealing or blocking their actions. Under the rule, the agencies have to notify Congress when a formal rulemaking is done. It doesn't, interestingly, apply to executive orders, rules affecting agency personnel, or rules regarding internal agency operations. But it is a powerful tool, and it's a blunt instrument. The rule is wiped out. It's not, you don't take, Romanet 3 out and leave the rest of the regulation. The whole thing gets wiped out. And perhaps as powerful, maybe even more powerful, is that the agency can't just go, and we'll just issue the same rule again, and we'll change a couple little things. No, if the resolution is successful, the agency cannot issue a new rule in substantially the same form. The issue of whether a new rule is in substantially the same form has not been litigated, and that's sort of one of those quagmires that lawyers live in as to whether something's substantially the same. But you would think the agencies, if they went through the CRA process, would try to really change the rule to deal with the concerns that Congress expressed when it ultimately passed that resolution. It was used some during the Trump one, and it's already, and we'll look in a second at some slides that show you that it's being used actively already. So this is the process. The agency rule has to get reported to Congress. It's published in the Federal Register. A lawmaker can introduce a joint resolution of disapproval within 60 continuous session days of Congress receiving the rule. There's some odd rules for calculating 60 continuous session days. It's sort of like business days. It gets referred to the committees, but it can be removed committees or discharged after 20 days with a petition signed by 30 senators. So it's a little easier to get things from getting locked up in committee, at least in the Senate. And what you'll see oftentimes are dear colleague letters among senators or congressmen trying to rally support for various CRA resolutions. It's not subject to the filibuster in the Senate, which again is a powerful tool. There's less of a formal procedure in the House for the initial floor consideration, but the majority can get it there pretty quickly at any time. The president can sign, veto, or take no action, pocket veto on a disapproval resolution as with a regular bill, to override a veto, you need 2/3 in both chambers. And here's some of the regulations that have been repealed already. You've got a Republican-controlled Congress and someone, Republican in the White House. So these are the ones that have gone so far, mostly focusing on environmental issues. But the CFPB had one of its regulations overturned. The CFPB has also, been shrunk considerably. It's dropped 2/3 or more of the cases it's brought. A lot of those were advertising cases or had advertising or unfairness aspects. So the agency went about it in a different way there. With the CFPB, the agency literally went through every case on its docket and with input from the White House made decisions about whether cases were going to live or die. And a lot of them died. Some of them are still going on. But this gives you a sense of the breadth of things that the Republican majorities are pushing, the types of regulations they're trying to repeal. And you'll note that the negative option rule was not on there. And if you had asked me before right before Inauguration Day, I would have told you that I thought that the FTC's negative option rule, click to cancel, as they like to call it, will be subject to a CRA and would be also perhaps not be defended in court. And I was wrong on both of those.
Well, I remember, Len, how many calls had we been on when we were talking about that, and we were just talking about everything the FTC was doing and saying, okay, well, is this going to impact, what do we think the click to cancel rule is going to do? And
Yep.
that was just, that's I think how a lot of this is. So that we're looking at is trying to read the tea leaves, and we're really doing the best we can. And to your point earlier, Len, I think looking at what they are enforcing and what mechanisms are doing it and what provisions are doing it under is going to be our best way of, we can never predict the future, but it can give us some information about where we anticipate they might go and how they'll get there.
Yeah, I think what's challenging right now is our sample size is really small. I mean, if you look at, it takes 6 months to a year typically to, from, somebody saying, hey, we ought to look at this, to you seeing public FTC action. So most of the cases that have been brought so far are ones that were started under Shere Khan. And so, it's a little challenging to figure out exactly what the agency's priorities are. I mean, we know they dropped a couple of COVID cure cases. I think those are the only consumer protection cases where the agency sort of, went and sort of undid things that were being done under the prior administration on cases. We mentioned the Robinson-Patman case, the one they killed, one they kept. So, the sample size is small, and the agency's moving slowly. You've got a lot of new people there. I think given the layoffs and some of the rhetoric, the agency's not moving at a tremendous speed. We'll see if that changes. Okay, I think this one, you're talking about the Golden State.
Well, we're going to be talking a lot about California, as you can imagine, when we're talking about what regulators are going to step in, and what class action plaintiffs for that matter. And California, in addition to implementing new laws and regulations for anybody who's selling inside California, which we'll talk about, it's also fighting back on the federal level against certain actions that are happening here. So under the CRA, the Senate had voted to overturn a waiver that essentially allowed California to set its own air pollution standards that were stricter than national regulation. So in other words, they're saying, okay, well, the national regulation is fine, but we're going to impose something that's stricter. And they needed a waiver to do so. And they sued. So California fought back. And a nonpartisan GAO report had actually been issued saying that using the CRA to repeal that waiver was unlawful. It wasn't the appropriate use of the CRA process. And what we're seeing is that California, a lot of its different regulatory bodies are becoming very vocal, not only in fighting in court, but also just in open statements about what the federal government is doing. They've become a lot more vocal about their own priorities and where they think the gaps are in the federal government and the federal enforcement priorities, particularly in the areas of, as Len said, environmental and also consumer protection. Oh, our favorite.
So, lots of states are supplementing their consumer protection laws. There are many FTC acts. We've seen a lot of activity with states enacting negative option laws. California was one of the forerunners there, but there's now in at least a dozen states and probably more on the way. New York, which has already been a very active consumer protection state under Attorney General James and also under her predecessors, she's trying to get the legislature in Albany to pass the Fair Business Practices Act, which in her words would close loopholes in the current consumer protection scheme. I think anybody who's dealing with the Attorney General doesn't feel like there's too many loopholes, but it would give the AG the ability to pursue civil penalties and restitution for violations of this act, and would cover conduct such as subscriptions of even additional. There's already one New York statute that deals with negative option marketing. This one would really focus on the subscriptions, deal with student loan servicing, car dealers, nursing homes, and abusing consumers with limited English proficiency. Really kind of micro level regulation of conduct, but with very serious consequences. New York has historically taken a very broad approach to what conduct is subject to the New York consumer protection laws or any of New York's laws, including the securities laws. And if the company is headquartered in New York or the call center is located in New York, the computer servers are located in New York, they will take a very broad approach as to what consumers have been affected by conduct covered by the statute, and that can ring up big dollars on both restitution and civil penalties. So don't see any signs that New York's approach is going to change here. A little unclear, I think, on whether this statute gets passed, but it's a democratically controlled legislature, but it's also an election year, so who knows what's going to happen.
I agree. And as you said, Len, the Attorney General's office at New York is being very aggressive. I know we're defending a few of the investigations that they've brought, but we know for a fact that they're not willing to, or they are willing to file lawsuits. Sometimes we have AG's offices and California DAs that we can sort of grind down and get really favorable settlements. But what I think we're starting to see is that the New York AG's office is being a lot more stringent in its first of all, the settlements that it's extracting, as well as its willingness and aggression in lawsuits.
The one thing I think we are seeing a little bit of with AGs across the country is because there's, especially the Democratic AGs, they're spending so much time fighting with the administration that their resources are a little constrained right now. And you would hope if you're representing somebody in front of them that maybe that inures to your client's benefit because they're a little more reasonable, and so they don't have to litigate, because they can't litigate every case and fight with the president. But we'll see. I mean, I think the rubber. We'll find out when the rubber hits the road exactly what that means.
Absolutely. So one of the hot topics of the day, the topic du jour, is environmental advertising. As a brief reminder for everybody, that Federal Trade Commission issued green guides many decades ago that are just guides. They're not a trade regulation rule that govern or provide guidance concerning certain environmental advertising claims. Claims like environmentally friendly, eco-friendly, very broad claims, but also specific guidance with more specific claims. Things like biodegradability, compostability, made from recycled materials, recyclable, a lot of different things that the FTC green guides currently, which as they stand, they govern. They were last updated back in 2012. And in 2022, the prior administration under Khan, they issued a call for comments because every 10 years, they're supposed to update guidance documents. So that in 2022, they sent out a call for comments. I think it was in December. They waited till the last minute. They got rounds of comments in. They held a workshop on recycled content claims, and then they didn't do anything. Even though they had a couple of years, the prior administration did not update the guides. They didn't even issue proposed, like, hey, these are the proposed guides, and then we'll finalize them later. That did not happen, which I think came as a surprise to a lot of us who practice in this area.
I was shocked. I mean, I was on panels last year and the year before talking about everyone was predicting when the green guides were going to come out, and I don't think anyone said never. And given the current administration, I don't see those guides coming out anytime soon. And the guides were useful in giving businesses some insight into how the FTC might, enforce environmental claims. Now, if they're not going to be enforcing environmental claims, then maybe we don't have to, at least from the FTC's point of view, you don't have to worry, but you still have to worry, as Shahin will tell you.
That's exactly right. We're seeing a few different things. We're seeing class actions being filed, which we'll talk about. We're seeing state and local regulators challenging companies' environmental advertising claims. And we're seeing new state laws emerge that are really stringent about what you can and can't say, that are providing class action plaintiffs a new avenue to target it. Setting the stage for where we are in June of 2025, I would say that class action plaintiffs' attorneys have seen an opening here and are really taking advantage of it. We're seeing a lot of lawsuits being filed in areas that were a little bit quieter before, or they couldn't even file because the states hadn't really passed laws and regulations that would have given them an avenue, a really clear avenue to file a lawsuit or extract really expensive settlements. The environmental advertising sphere is one of those where we have seen a number of new laws. California had an existing law regarding biodegradability and compostability, where it essentially said, if you ask a regulator, you can't say biodegradable at all in your advertising. I challenge that because the statute's written a little bit unclearly, but it also says you can't make compostable claims unless you pass one of 3 ASTM standards. That law was just updated, in fact, to say that now if you want to make compostable claims, you have to also meet specific requirements beginning January of 2026, including only having ingredients that are considered organic under the USDA's rules, only including up to a specific amount of organic fluorine. In other words, PFAS. We always talk about PFAS. We're seeing a lot of PFAS lawsuits out there. So California has issued that. California also has a law regarding recyclability, where if you're going to make recyclable claims and you use the chasing arrows, you have to be very specific about when and how it can be recycled. They're issuing new guidance about what type of recycling facilities are available in California and how they're available, which would preclude, in some instances, companies from saying recyclable at all, even if they are potentially or theoretically recyclable, or if they're recyclable in other states. If you want to make that claim on your package, you might not be able to make it in California. So being mindful of that. We're also seeing class action lawsuits that are being filed with differing layers of success. We put Lululemon here first, and this is actually, Lululemon won in this case, the plaintiffs lost. And in that case, the plaintiffs were challenging Lululemon's claims back in 2020 about its Be Planet promotion, saying we are going to have 50% less carbon offsets in the year 2024. And then in 2024, the plaintiffs looked at it and said, whoop, time's up, you don't have it, and you're making all of these other claims. And they were looking at the calculation and things like that. And Lululemon fought back on various things like its disclosures and the reasonable consumer, and the court actually dismissed that case. We're seeing another case against P&G that was recently filed that's challenging for the Charmin toilet paper, claims that for every toilet paper package that's sold, P&G is going to plant its own tree. And what the plaintiffs say in that case is that where P&G actually sources the trees, they're in a forest that has very unique biodiversity and carbon offset benefits. And the trees that P&G is then replanting in that same forest don't provide the same biodiversity and carbon offset benefits. This idea of, well, you're taking these really valuable trees and you're planting something that's not as valuable. So any claim that you're making about the environmental benefit is therefore inherently false, which I have my own opinions about. I think it sort of stinks because somebody's trying to make an effort and now you've got plaintiffs who are coming after you for making that effort. But we're watching to see how that one's going to play out. Another case was filed against Apple for their Apple Watches. Claims were made there about the carbon neutrality of those watches. And plaintiffs were saying, no, that's not true. You're falsifying the carbon benefits. You're calculating it stage 2 emissions versus other emissions. And therefore, well, that is false as well. We have the California Greenwashing Task Force that has come out in recent years, and that's a task force of district attorneys in California. For those of you who don't know, California DAs for the different localities and cities can act the same as state AGs in other states. And what they'll actually do is they'll bind together, they'll bring cases, and then they'll extract really high penalties. And that is how they fund their offices. In some ways, I almost think of them a lot like class action plaintiffs attorneys because they really want funding.
Agreed. I mean, they're self-funded. They have they don't have incentives to not pursue cases. The other California is a hotbed of environmental litigation. So not only do you have the class action bar, not only do you have the district attorneys, you've got a very aggressive attorney general and Attorney General Bonta. He's brought 2 very big cases against both against Exxon, one against Exxon and some others. One is in Southern California against Exxon for greenwashing the effect that petroleum products have on climate change and global warming. That is a knockdown, drag-out fight. Similar claims have been brought by 11 other states and several state and local governments. And what's fascinating is a bunch of Republican states went to the Supreme Court and filed a lawsuit in the Supreme Court trying to get the Supreme Court to order that the Democratic states stop this because it was violating the nature of climate change and the nature of the way that these products are produced and sold. It's a multi-state issue, and one state shouldn't be regulating commerce in the other. The Supreme Court declined to hear that case, so the cases are going forward. Some of them have been successful, getting past motions to dismiss. Other cases have not. It's very similar claims, but just different judges. And you've got issues about, a lot of these cases use public nuisance, and there's a split as to whether, climate change is a public nuisance. There's causation issues. There's the extent that it's seeking monetary relief. There's, how do you, whatever apportion to a single state, alleged monetary injury, whether the claims regarding the environmental impact of petroleum products, whether consumers knew that petroleum products had an effect, whether the opinions that the oil companies made, is that puffery? Were they opinions? Were they statements of fact? Really fact specific, and also how you look at all this. Do you look at individual ads, or do you look at the mosaic of years and years of advertising by the oil industry, with beautiful seashores behind them or in front of beautiful forests? These issues are gonna get played out for a while. There's been efforts in the Congress recently to have legislation enacted that would block these. I don't think that's going anywhere, but who knows? But it's a big issue. The New York AG has gone after 2 big food companies on plastic. Against Pepsi on plastic issues, trying to hold Pepsi, which is also Frito-Lay, responsible for the amount of bottles and bags, Dorito bags, potato chip bags that were in the the rivers near Buffalo. And Pepsi filed a motion to dismiss, and they were successful. The judge saying, it's just a bridge too far to hold somebody who sells food responsible for how consumers ultimately dispose of the packaging there. California has also brought a greenwashing case regarding plastic recycling, claiming that the plastics industry, primarily Exxon and the other polymer companies have lied about the effectiveness of both chemical and mechanical recycling, and that they've sort of convinced the public that recycling works when it really doesn't. Really interesting case. DC Attorney General is involved in similar cases against Exxon as on the climate change. That's probably enough on that one. But I mean, this is the one area where I think the federal government is not doing much on environmental advertising, and the states, at least the democratically led states, have jumped in with both feet.
And one thing I just wanted to remind everybody of is that even though the green guides have not been updated since 2012, plaintiffs are still using the 2012 version in their complaints and saying the court should look at this when you're evaluating the claims. And courts, in their denying a motion to dismiss, have said, well, the FTC green guides say this, and therefore we're going to apply this standard, even though that's about nearly 15 years old.
Very common.
Junk fees and transparent pricing. We talked a little bit earlier about the FTC's junk fees rule and how it was significantly limited in its final version. It would have applied to every industry. This idea of, if you're going to advertise a price, you have to advertise the whole price up front if there's any mandatory things that a consumer is going to pay. Now, we then saw a law passed in California, Cal Civil Code 1770, and we are seeing, I kid you not, at least one lawsuit filed a day. That's putting aside all the demand letters we're getting behind the scenes on this stuff. And what those lawsuits are generally alleging is that the defendants are not advertising the all-in prices at the time they're displaying they're displaying the prices to consumers, including optional things that somebody can check out, they can uncheck at their checkout page. So one thing that we're seeing a lot of are challenges to shipping protection programs. Hey, pay $3.99 and we'll put shipping insurance on your in connection with your order to make sure that if it gets lost, we'll insure for that. And a lot of plaintiffs are saying, well, you snuck it into my basket at the last minute. And even though I was allowed to uncheck it, if I didn't uncheck it, then I end up paying the $3.99. So we're seeing that a lot. We're seeing a lot of these in the tickets industry. Somebody has to pay an extra service fee for a ticket. We're seeing it in the food delivery industry. The FTC and others had actually taken issue with this a few years ago, but now we're seeing it on the class action side.
And I think what this means for marketers is, just because the click to cancel rule, junk fee rule, are a little uncertain right now as to what's going to happen, and especially on the junk fees. I mean, the plaintiffs' class action bar is all over this, and some states have statutes that help the plaintiffs' class action bar, but just under their general deception theory, they're just going to argue that this pricing as advertised was deceptive. And damages are pretty easy for them. It's the amount of the fee times how many people bought it. It's pretty well suited to class action treatment. We might argue otherwise. In certain cases, it might be easier than others. But if you really should be looking at how your prices are displayed, because the other thing you should pay attention to is you're getting lots of calls and complaints that people are saying, what is this fee? I can't believe I got charged for this. Ultimately, somebody's going to call a lawyer if you're getting a lot of those complaints, and one lawsuit is going to cost you an awful lot of money. Multiple lawsuits are going to cost you multiple large amounts of money. So this is one where you really need to be smart.
Absolutely. In addition to auto renewal programs that we talked a lot about, this is something that, just like junk fees, we are seeing such a large uptick in this. Back in the day, like a year or two ago, we were seeing one lawsuit filed every couple of weeks. Now it's, again, at least a few lawsuits a week. And these lawsuits are typically filed under California's auto renewal law, but we're also seeing it under New York's automatic renewal law. Those have general provisions about disclosing the subscription terms, getting people's agreement to the subscription terms, letting them cancel the subscription without having to jump through a million hoops. But we're also seeing a lot of these challenges start to focus on really technical violations. So, for example, your language must be clear and conspicuous. And under these state laws, clear and conspicuous means it must be in a larger font than the surrounding font, or set off from font that is the same size in bold or other types of symbols or darker font. Even North Carolina, we saw a lawsuit because you need to have bold language in the disclosure if you're going to change the price. California's law, which is going to take effect here in a month, says that even if you get consent upfront to somebody's changed price, like you're going to pay, let's say, $10 for your first shipment and then $30 for the next, and you disclose that upfront, California says you still need to provide additional disclosures about that after that initial purchase. And so here are just a few of the lawsuits, and some of the things are very, very technical. The Go Car Wash Management Corp, it had issues about disclosures, but they also sued under the Electronic Funds Transfer Act by saying, well, you didn't give me a physical receipt, and that violates the Electronic Funds Transfer Act. So now we're going to sue you and try to get millions of dollars for you. Just this week, SeaWorld had a $1.5 million settlement for its sea pass. You could pay a certain, it's like your pass for the season, and you go to SeaWorld as much as you want. And that auto renewed apparently, and people didn't know it, and they complained about it. And finally, made in the USA claims. Len, you had mentioned earlier that the FTC is probably going to keep enforcing these, particularly as the focus on American made is becoming a very hot topic for the administration. We do have this FTC settlement that happened.
Yeah, and it's interesting. So Congress authorized the FTC to issue a Made in the USA rule regarding claims made on labels. The FTC then promulgated a rule that really dealt not just with labels, but with advertising on the internet as well. The Republican commissioners at the time said, you're overreaching. This is administrative creep. This is improper, and dissented from that part of the rule. But it's being enforced. The FTC is using it. This has been identified by Chair Ferguson as one of the areas, and given sort of the overall gestalt of the Trump administration on bringing manufacturing back to the U.S., this has to be something where you're going to see the FTC be very active and really pushing the bounds of the rulemaking authority that Congress gave it. And someone might litigate it and challenge it. We'll see. But you're going to see a lot of enforcement here. I would be shocked if you don't. And they'll use the rule to try and extract penalties.
Absolutely. And in the meantime, you are seeing class actions here. You're seeing class actions against companies that are advertising, for example, Nordic Ware, they had cookware that was actually made in Canada, but they were advertising it as American made. We just saw a settlement in a case involving tea, the Banks case. I think they settled for 2.5 million, 2.4, 2.5 million. They advertised the tea, it's made in the USA. In fact, it was made in India. So we think that's going to embolden plaintiffs in particular now that that they're getting those settlements. They're able to move forward on those cases.
Before we sign off, a couple of things. Code is FTC 2025 for CLE. Our next Deregulation Nation session is on June 10th, where you'll hear about changes at the Patent and Trademark Office as well as the Copyright Office. Thank you all. Shahin, any wise remarks to close this?
No, if you want to stay updated though, you can subscribe to our our blog, listen to our podcast, and check out our toolkit, and we'll be keeping you updated. And if there's one takeaway, it's that we're all getting deregulated somewhat, but if you're in the consumer protection, advertising, and marketing space, don't sleep on compliance.
No, you'd be foolish to do so. Thank you all for attending. Enjoy the rest of this beautiful day, at least in New York.
Thank you all.